Agenda number 4, case number 126271, People of the State of Illinois versus Antoine Teddy Eubanks. Mr. Kohat, when you're ready.
May it please the Court. Good morning, Your Honors, Counsel. My name is Brian Collette. I'm at the Office of the State Appellate Defender, and I represent Mr. Antoine Eubanks, the defendant in this criminal matter. The question before this Court is whether Mr. Eubanks was engaged in plea discussions where the prosecutor had the power to accept or reject his inculpatory statement as truthful. And even if the statement was a result of the deal, whether it should still be protected under Supreme Court Rule 402F and Illinois Rule of Evidence 410. As a preliminary matter, Your Honors, defendant argues that both Supreme Court Rule 402 and Illinois Rule of Evidence 410 apply. However, during argument, I will likely refer to 402 as a matter of convenience. But both, when I'm referring to 402, it applies to both rules, in Mr. Eubanks' opinion. The initial inquiry here is whether defendant's proffer was made before the deal was final or after the deal was finalized. The uncontested facts show that the statement was made before the deal was final. Now, the state approached defendant with a proposed deal. Defendant would plead guilty, give a truthful statement, and cooperate against his co-defendants, all in exchange for a 35-year sentence. Pursuant to this negotiation, Mr. Eubanks gave a candid, recorded proffer to detectives with the prosecuting attorney sitting right outside of the room, texting questions into the detectives. At one point, Detective Karzan said, "I have to ask the way they want me to ask," to ensure that he was getting the statements that the prosecutor wanted. The prosecutor's presence outside the room was there to ensure that she got the statements that she needed. At the end of the defendant's proffer, defense counsel went out to talk to the prosecutor to, quote, "make sure we're good." After he talked to the prosecutor, he came back into the room, and the interview lasted for a couple more minutes, showing that the prosecutor was not completely good. She had additional questions that she wanted the defendant to answer. And the prosecutor, during the stipulated bench trial, stipulated that this statement was a proffer. A proffer is a legal term of art. A proffer is often used in the federal system, and it describes the statement, what the defendant is willing to give, the information that the defendant is willing to give to the prosecutor listens to that information, and based on the information, whether the prosecutor will decide to give a deal.
In the federal system, aren't proffers usually memorialized in a letter, so there's some writing, so that everyone is clear on the understanding?
They often are, yes, Your Honor. Here, there was absolutely no written, agreement. There was no written proffer. There was nothing written here, Your Honor. And that burden should be on the state. The state is the one that proposed the deal to the defendant. They're the proponent of the agreement here. So anything that's not in writing should be against the state.
But when the agreement took place, seems to be the key determinative here, the timing of when the agreement took place. There's nothing in writing about that, correct?
There's absolutely nothing in writing about that. We're going off the totality of the circumstances by the facts presented in this case. And here, the facts all show that there was no agreement until that statement was completed, until that proffer was completed.
Well, let me ask you that. I mean, we had a third stage post-conviction hearing in this case where the defense attorney testified, contrary to what you just said, that there was an agreement that was finalized before the statement was made, and that attorney would have never authorized the client to make that statement if the agreement was not final. And then the defendant, in his testimony, agreed with that. So how do you say that this is beyond a doubt uncontested facts that it was before when it was actually testified to at the hearing? Well, it was after, and we're talking about manifest way to the evidence review here on those factual findings.
Well, initially, Your Honor, he did say that these were plea discussions. He was asked specifically, would you call these plea discussions? And his unequivocal answer was yes. And then he went on to qualify that answer. Now, we don't have a written agreement, but we have all these facts showing that if there was already agreement in place, there was no reason for the prosecutor to be there. There was no reason for her to be texting questions into the detectives. I mean, I would think she would have better things to do.
Well, I totally disagree with you on that. There's absolute reason for a prosecutor to be there to make sure that the agreement is being complied with. Because if the person is making statements that the prosecutor who's investigating the case and what the police knows are false, then that means that your client would be in violation of the agreement.
And if there was an agreement before that, perhaps that would be the case. But there would be no reason for her to be there at that point. She would have a statement subsequent to whenever it was given. It was all video recorded. The detectives could inform her, he lied. And then she could come back and say, well, there's a breach of this deal. She doesn't have to be there to observe that in person to determine subsequently whether the deal has fallen through.
Well, I mean, we can talk about this for a long time, but I mean, I guess what I'm getting at is you're talking about uncontested facts. And then you start talking about contested facts. You're talking about the attorney first saying they were plea discussions, then later clarifying upon questioning that the agreement had been finalized before the statement was made, the defendant agreeing with that, and then on the stipulated trial, the state, for whatever reason, calling it a proffer. These are facts that seem to be in somewhat dispute, but we have a trial court making a factual finding that the agreement was in place before the statement was made, manifest weight review. Again, how do you respond?
Well, again, Your Honor, I disagree. We have no findings of credibility. We have no credibility determinations here. We have the facts as they're presented by the attorney, by the defendant. The state does not come in and say, well, no, that's not the way this happened. So the facts are what they bear out from this cold record. That's how we're looking at this, at determining they're uncontested. The facts are what they are. They are his statements that were made on the stand, the facts, what occurred during that statement, during that proffer, who was present at that proffer, the fact that defense counsel has to go out and make sure that we're good. And then we have contradictory findings by the circuit court, Your Honor. We have originally his verbal ruling was, and I have it quoted here, he found that the deal was as I set forth, that it was, he had to plead guilty, give a truthful statement, and cooperate against the co-defendants in exchange for a 35-year sentence. And then he went on to say they had their opinion as to what the truth was, and I'm not sure if he gave a statement that didn't comport to that, the deal would have been off. This is a finding that there was no deal in the first place. He had not given the state what it wanted, the state would have said no deal and simply could have walked away from that plea discussion. Could have said if the defendant would have lied during that proffer, the state just would have said we don't have a deal. It's not subsequently whether there would have been a breach of that deal. And as to the manifest weight of the evidence standard, that's the state's sole argument with regards to this portion of defendant's position. This court has always looked at decisions interpreting Rule 402F, whether the plea discussions under the de novo standard of review.
Is it your position that the plea discussions don't end until they're accepted by the court?
No, that's not our position. Our position is whether we have to look to when the agreement was finalized. And here, the totality of the facts and the circumstances show there was no agreement until the state agreed that they would accept that statement.
So they could be finalized prior to the time that the court addresses it and accepts the plea formally.
I think there's other cases that might suggest where a defendant might argue that maybe his statement before the grand jury before he pled guilty was not part of a finalized agreement. But here, the position here is that there could be a finalized agreement before that plea of guilty.
So it's a factual determination in every case as to when plea negotiations start and when they end.
Well, when the facts aren't in dispute, and we're not disputing the facts here. When the facts are not in dispute, it's like contract law. The determination of whether a contract came into being is based on the totality of the facts, the totality of the circumstance. It's a legal conclusion, though. It's not a factual finding, oh, here was the contract. You have, one party will come in and say, this is what we said. Another party comes in and says, this is what we said. And it's up to the court to make that legal conclusion as to when that agreement was finalized. Here, as pointed out, he makes contradictory conclusions. He first says that there was no deal until the state could have walked away from the deal if they didn't get what it wanted. And then in his written ruling, he decides that yes, there was a finalized agreement before the statement was given. But you look at the circumstances surrounding that statement, and it's apparent that that deal is not finalized until the statement is completed. If the statement was already finalized, if the agreement was already finalized, there's no reason for defense counsel to go out and talk to the prosecutor to make sure we're good. He would have known what the statement was, what the discovery showed, whether that statement was compliant with the agreement, and potentially whether there's a breach. And if there's even a breach of that agreement, there's nothing more for defense counsel to do at that point. It's up to the state to bring forward that breach and argue that, hey, we don't have a deal because the defendant breached it here. In his opening brief, defendant discussed a number of cases to show the continuum for where these statements are made, where these proffers are made before or after an agreement. One case I would like to point out is this court's decision in Mack. There, the defendant and the prosecutor negotiated a deal whereby the defendant would plead guilty to a natural life sentence, with the caveat that the victim's family had to approve first. The victim's family never approved, and the defendant came back and said, I should have gotten this natural life sentence. He was tried under death penalty provisions. The circuit court, and this court agreed, found that victim's approval is a petition precedent to that deal being finalized. Here, it's the same thing. He has to give that truthful statement. If he did not give a true statement, the state would have gotten up and left, said, we don't have a deal. Even if this court should hold that the statement was made after the plea had been finalized, it should determine that a proffer given to a prosecutor in exchange for sentencing considerations should still be inadmissible under Rule 402F. It's important to note that we're not talking about an independent admission. We're not talking about statements given to a grand jury or statements at a co-defendant's trial. This was a proffer given to the prosecutor. The defendant's statement was so intertwined with those plea discussions that it should be protected under Rule 402F. Now, the purpose of the rule supports Mr. Eubanks' contentions. The rule was adopted to encourage candid plea negotiations. If a defendant would understand that his statement would be given as part of a deal would be admissible, he would be reluctant to give any such statements. The prosecution it's harder to get these statements. The prosecutor has a harder time gaining the leverage over his co-defendants. The victims in the case lack closure. The truth never really comes out. Allowing these statements would hinder the flexibility necessary to negotiate plea deals and have a chilling effect on plea discussions.
Do you have any case law to support this argument?
It's policy considerations given by this court as to the purpose underlying Rule 402F is to foster candid negotiations.
Right, but the cases are, replete the opposite way.
As far as
if the statement is made after the agreement is reached, then 402 is not implicated.
Well, first of all, this is the first time this court has ever had to deal with this situation under its rules.
I understand. I'm talking about all the appellate court cases.
Sure, and there are
and all those cases.
There are two cases where actually the agreement was finalized and the statement that was made after that was determined was inadmissible. Grant and Ragusa are both of those cases. In Grant, the defendant gave his statement to an FBI agent. They negotiated an agreement. It was a cooperation agreement. And then it was the next day he spoke to the prosecutor. The court in Grant found that statement the next day was part of the ongoing discussions and found that statement was inadmissible. So there are cases on point here. And the state suggests that this, and it's a matter of policy, Your Honor. If Rule 402F does not apply, statements would be admissible no matter who reached the deal. And the inequity is particularly apparent here because it's the state's error that resulted in the termination of the plea here. The state's factual basis showed a firearm had been used in the offense. Therefore, under this court's holding in White, a 25-year add-on was required to be added to the sentence. And contrary to the state's position, an amendment to the charge would not have cured this error. If use of the firearm is mentioned in the factual basis, then the mandatory add-on applies. With this, defendant's plea was void. It could have been attacked at any time. He had no choice but to withdraw his plea here. And ultimately, we want these proffers, Your Honors. The state wants them to find the truth and use it against co-defendants. Defendants want them to leverage a better deal. Protecting and encouraging proffers fosters guilty plea negotiations and fosters guilty pleas in the long run. And the state argues that counsel did not perform deficiently. He argued as a matter of strategy that the plea agreement was void. The plea agreement was not void. However, the guilty plea was later voided out by the factual basis presented by the prosecutor. At the time the agreement was made, it was fine. So that could not have been a matter of trial strategy here. And Rule 402F provides the obvious avenue for attacking this admission. And finally, the state argues that the defendant did not suffer any prejudice. The court's ruling is contrary to that assertion. The court found that the defendant was prejudiced. And this court has repeatedly found that the proper admission of a statement made under Rule 402F, a confession, cannot be harmless. And if counsel had not performed deficiently here and would have moved to bar the proffer, then the statement would have been admissible and defendant would not have proceeded by way of a stipulated bench trial. Finally, the defendant did not stipulate to the truthfulness of his statements. At a trial, the state's evidence would have been dependent on the highly intoxicated accomplices who provided multiple contradictory statements and would have been subject to vigorous cross-examination. This court has repeatedly found that such credibility contests satisfy the closely balanced prong of the plain error analysis, and that should apply here in looking at the prejudicial effect underlying these statements. Finally, a finding of harmlessness after stipulated bench trial would render stipulated bench trials nugatory. A defendant would simply insist on having a full-blown trial instead of a stipulated bench trial. In conclusion, the state's power to accept or reject a proffer as untruthful shows that no deal had yet been in place and defendant's statement was given during plea negotiations. Even if a plea deal was in place, a defendant's proffer to the prosecutor given as part of a bargain to plea deal should still be barred under Rules 402F and 410. Accordingly, Mr. Eubanks respectfully requests that this court reverse the appellate court and circuit court decisions in this case and remand the matter for further proceedings.
Thank you, Mr. Cohen. Mr. Jason Kriegel.
Good morning, Your Honors, Counsel. May it please the Court, Assistant Attorney General Jason Kriegel for the people. Defendant began his argument this morning by saying that the issue before this court is whether 402F applies to the videotape statement that he gave. But I want to take a step back for a moment because that's actually not the question that's before the court this morning. This is not a direct appeal raising an evidentiary issue. It's an appeal from the denial of a post-conviction petition after a third-stage evidentiary hearing. And so defendant has three burdens, really, to make here. First, he has to show that his lawyer, Attorney Neiman, provided objectively unreasonable representation. He has to show that if Neiman had raised this 402F issue, that his statement would have been suppressed, and he has to show that if the statement was suppressed, that there is a reasonable probability that he would have been acquitted at trial, and defendant has not made any of those showings. Turning first to the first issue, to the performance prong of Strickland. Defendant, again, has to show objectively unreasonable performance, and Strickland starts with the presumption that counsel acts for strategic reasons. And here, I think that, as Justice Burke pointed out, there were clear strategic reasons for counsel not to raise this 402F argument, because the state appellate case law, as well as the federal case law, unanimously had interpreted plea discussions, the term that's in Rule 402F and in the federal rules, to mean the negotiations, the statements that are given as part of negotiating a plea agreement. And once the agreement is reached, statements that are given in performance of that agreement, when a defendant agrees to make a statement as part of the deal, those are not covered by the rule. And if counsel, or when counsel, presumably when counsel conducted his factual investigation, he would have spoken to Attorney Dalton, who represented defendant in negotiating the plea, and Attorney Dalton would have told Neiman exactly what he testified to at the third stage hearing, which was that I never would have allowed defendant to give this statement if we had not reached the plea agreement first. And so it was perfectly reasonable for Attorney Neiman at that point to decide this Rule 402F argument is not a winner. I'm much better off arguing what he did argue, which was a perfectly reasonable argument for suppression. Ultimately, it turned out to be unsuccessful, but defendant has not disavowed it. He's not claimed that it was an unreasonable argument. In fact, he seems to repeat the same argument here today, even though that's not the issue before this court. And so turning then to prejudice and to the question of whether defendant's 402 argument could have succeeded at a suppression hearing, there are really two disputed issues in this case. One is a legal issue and one is a factual issue. And as the court pointed out, obviously the legal issue of how you interpret the words plea discussions is a legal question, but the question of when did the parties reach an agreement, was it on a Tuesday or was it on a Wednesday, that's a factual question. And that is reviewed for the manifest weight of the evidence standard. So starting first with the legal question, the issue is, what does plea discussions mean in Rule 402F? And of course, the natural meaning, as all of these cases have held, is that it means negotiations. And defendant says, well, the rule should really encompass something more. It should encompass statements that are given pursuant to a plea discussion. But he has no textual basis for that argument. He can't point to any words in the rule that would lead to that conclusion. He only relies on policy considerations, which of course are not enough to overcome the text. But as we discussed in our brief, those policy arguments aren't really even persuasive, because once the parties have reached an agreement, there's no concern about a disincentive for giving statements after the agreement is reached, because the parties control what's in the agreement. So the defendant could say, I'm not agreeing to give a statement if he's worried about how that statement might be used, or he can say, I'm not going to agree that that statement will be admissible if I withdraw my plea. Now, of course, when the parties reach an agreement, they fully expect that that agreement's going to be carried out. So there's little reason to think that the defendant's statement will ever be used against him. There wouldn't even be a need for that. Defendant also has suggested that the people are going to be able to breach agreements and then gain the advantage of using statements that they've gotten defendants to agree to. But that's simply wrong under US Supreme Court case law and this court's cases. We cited Santabello and an appellate court decision, People versus Pearson, in our brief. I'd also point the court to People versus Starks from this court from 1985, which held that once the defendant had performed his part of a cooperation agreement, he was entitled to specific performance of that agreement and to have the charges dropped. The same would have occurred here if defendant had truthfully cooperated and then the prosecutor had done what counsel suggests she might have done and said, no, I'm not going to accept that. Well, defendant would have been entitled to specific performance of his agreement that they had fully negotiated at that point. So it simply should not be a concern in interpreting Rule 402. Now, moving to the factual determination here, the factual question that's at issue. I would point the court to page C461 of the record. This is the trial court's written ruling following the third stage hearing. It's very clear. The court says that the agreement was reached before the April 2011 statement was given. That was certainly not against the manifest weight of the evidence. It was well supported by Dalton's testimony, which I discussed, and as Justice Burke pointed out, the defendant agreed with that testimony. He said he understood at the time that he gave the statement that he had agreed to a 35-year sentence. Now, defendant points to a couple of things that he says are contradictory. I don't think any of those show that the judge's determination was against the manifest weight of the evidence, but I also think that he's just wrong as a factual matter. First of all, there was a third stage hearing at which two witnesses testified immediately after the attorneys and the judge engaged in an oral argument, and that's the point where the judge suggested, oh, this deal would have been off if defendant had not been truthful. But as I said, and defendant was simply performing his end of the agreement, and he had agreed to give a truthful statement. If he had breached that agreement, then certainly there would have been consequences to that. But that doesn't mean that the agreement had never been reached. It's just, as in contract law, the difference between contract formation and contract performance. And the contract had been formed before this statement had been given, and then defendant was performing on the agreement. Defendant also points to the fact that the prosecutor was sitting outside listening to the statement being given, and as Justice Burke pointed out, there's good reasons for that. She could have been listening to make sure that he was being truthful and complying with his agreement. She was also intending to use this statement against the co-defendants. If defendant had later refused to testify or changed his story, this video recorded statement could have been used in the co-defendant's trial if defendant had been available as a witness. So it behooved the prosecutor to be there to ensure that everything she needed was on this video.
Counsel, as it relates to your specific performance argument, can you respond to the defendant's argument that the state breached this agreement by agreeing to a statutorily unauthorized sentence?
Sure, Your Honor. So the circuit court rejected this argument when defendant filed the suppression motions. Attorney Neiman filed a suppression motion making this voidness argument. Saying
and that was not argued on appeal?
That was not argued on appeal. So defendant has abandoned it. He's collaterally estopped from even arguing it at this point. But I think as this court, as Justice Tice's concurring opinion in the White case said, the court has left open exactly the possibility that the prosecutor had planned here, which was that defendant would be able to withdraw his plea and then enter a new plea and with a new factual basis with no firearm enhancement. And at that point, he would have been permitted to plead to the 35, or to be sentenced to the 35 years. And the judge agreed that that's that's what would have happened. And again, that ruling was not appealed. So then turning to the last issue, the issue of prejudice. And first with the standard, defendant has used the word harmless this morning, and he also used it in his reply brief, but I just want to emphasize the standard here is not harmlessness, it's prejudice. And it's defendant's burden to show a reasonable probability that the outcome of his trial would have been different. And here, the only evidence in the record is the stipulated bench trial, where defendant stipulated that his two co-defendants would identify him as the shooter, and that the police found his phone at the scene of the crime, and that witnesses observed his silver rental car in the alley behind where this shooting occurred. Now, defendant says, well, there are issues that my attorney could have impeached these witnesses on, could have asked them about their intoxication or some of the discrepancies between the statements, but all of that is speculative at this point because we don't know what these witnesses would have said if impeached. We don't know what the state would have gotten out on redirect. We don't know whether there was rebuttal evidence. None of this has ever been put to the test. Now, defendant had an opportunity, of course, at the trial itself or at the third stage evidentiary hearing to call these witnesses to the stand and do that cross-examination to show that there was a reasonable probability of a different outcome here. But he didn't do that, and it's impossible to see how he can show that possibility without actually challenging those witnesses. In defendant's reply brief, he does seem to make the argument that the lower courts here found prejudice. I don't think that's borne out by the record, but this court certainly is not bound by any prejudice finding that the circuit court made or that the appellate court made. And a defendant has also argued that if he's required to prove prejudice, then somehow stipulated bench trials will be useless. But that's just not the case, and there are many instances where stipulated bench trials are very useful when there's no material dispute about facts. If the question is whether, for example, the defendant's conduct is constitutional or it violates a statute, or if some indispensable piece of evidence is subject to a Fourth Amendment argument, for example, without which the state would not be able to prove, would be able to meet the Jackson beyond a reasonable doubt standard. So there are plenty of uses for stipulated bench trials, but here it's certainly not enough to show prejudice under Strickland. I'm happy to answer any other questions that the court may have, but we'd ask that the court affirm the judgment below. Thank you.
Thank you, Mr. Kriegel. Case number I'm sorry, Mr. Kohut, sorry.
Thank you, Your Honor. Just turning to the state's argument, kind of in sum, there's two prongs to any Strickland analysis, whether counsel performed efficiently and whether the defendant was prejudiced by the deficient performance. The state argues that counsel did not perform efficiently. Essentially, they're saying that he made a strategic reason why not to raise the Rule 402F argument. On direct appeal, we challenged this under the same rule. The court did not have enough information, so they suggested defendant file a post-conviction petition. Counsel who represented him filed an affidavit with that petition. He never mentioned that he decided to not raise this Rule 402F issue based on the strategic decision. And his motion would contradict any such rationale. He argued that the plea agreement was void. The plea agreement was not void. It was the guilty plea that was rendered void by the incorrect factual basis. And then the state also argues that the defendant cannot show prejudice here. But as stated, and I think the state acknowledges here, the trial court found that there was no prejudice here, or I'm sorry, that the error was was prejudicial. The state argues that this court can look at the findings and review that decision de novo, but you're looking at a full-blown confession. Defendant never would have proceeded by way of a stipulated bench trial if this confession was not admitted. So there would have been a jury trial. It would have been a hotly contested credibility contest between these two co-defendants, these two accomplices, and the presumption of innocence. And then turning then to what I feel is the main argument here is whether Rule 402F bars the admission of these statements. And that's the center of this issue. If Rule 402F barred the admission, then counsel should have raised it, then he performed deficiently, and then if it applied, then defendant has shown prejudice because his confession should not have been admissible. So the ultimate question is whether this statement should have been barred under 402F. And again, we look to the totality of the facts and the circumstances surrounding the giving of that statement. You have the detectives in the room with the prosecutor outside the room texting questions to the detectives, specific questions guiding his statement. The prosecutor referred to this as a proffer, and this wasn't an off-the-cuff remark made during arguments. This was in the stipulations themselves. So she negotiated that term in those stipulations. The defense counsel went outside to speak to the prosecutor to make sure we're good. And if there was already a deal in place, there's no reason for defense counsel to go out and speak with the prosecutor at that point. And finally, we have the trial court statement. And we do have contradictory statements from the trial court here. His oral decision, his oral determination was that if he would not have given a statement that complied with what the state wanted, the deal would have been off. And I think that's compelling here, because if defendant would have lied, if he would have not given a complete statement, the state would have declared no deal and walked away. There's not a question of whether maybe he gave a 75% statement and then the state said, well, okay, there's a breach here, and so they come back and negotiate the breach. And that's a problem with something, with finding that this statement was made after an agreement was finalized. If there's a breach, how do we determine that? Do we bring the prosecutor in to testify as to what the actual truth was? I mean, do we have an evidentiary hearing to determine what the prosecutor wanted, how much of what the prosecutor wanted that the defendant gave, whether that was a breach? So I think those are all considerations.
Counsel, alternatively, Saunders, citing the D.C. Circuit in Davis, talks about a defendant, in your argument, could breach these agreements unilaterally with impunity. And the state doesn't have a corresponding right to breach. The state would be subject to, as counsel argued, specific performance.
Well, I don't think there would be a corresponding right to breach. I think what happens when you have a breach, all parties lose. Everybody loses. The state loses its deal. They lose the plea. They have to bring their witnesses in. Now they have to have a full-blown trial.
Well, wait, if the defendant breaches and he's returned to the status quo ante, what does he lose?
He loses that 35-year deal.
Right, but he doesn't want it. That's why he's breaching it.
Well, I mean, he subsequently didn't want it, but apparently, but he made that decision. He was in the position where he had to make that decision because of the state's faulty factual basis. When the state presented a factual basis showing that a gun was used in those offenses, then he had no decision. He was either going to be stuck with a void sentence that could have been challenged at any time, or he would have to withdraw his plea and start all over again. So, and the state argues that, well, they could have reformed this by amending the charge. They couldn't have amended the charge because they brought in the gun was in the factual basis. And under White, that's what matters, is the factual basis.
Well, he would file a motion for specific performance, and if the trial court agreed with that motion, then the state would have to allow him to withdraw his plea, reform the charge to not have the dangerous weapon, to put a dangerous weapon as opposed to a firearm. You would have to go through multiple processes. It's not just withdrawing the plea and amending the charge. You would have to replete. And here, the defendant withdrew his plea, and apparently there's no
further negotiations. There was no opportunity to do that. After the state presented an erroneous factual basis, there's not much incentive for the defendant to say, okay, I'll trust you this time, let's go through with this plea deal. So I don't think specific performance would work here. You couldn't get that 35-year sentence after the state presented that factual basis, Your Honor. And for all of these reasons, Mr. Eubanks requests that this court reverse the appellate court's decision, reverse the trial court's decision, and remand this matter for further proceedings. Thank you.
Thank you. Number 126271, People of the State of Illinois versus Antoine Teddy Eubanks, known as agenda number 4, will be taken under advisement. Thank you, Mr. Kriegel, and thank you, Mr. Cohat, for your argument.